So, good evening everyone, especially again to my students from Moraya College and from Trinidad Municipal College. We are now on Title 2, Crime Against the Fundamental Laws of the State, from Article 124 to Article 133. And now we are on arbitrary detention. When we talk of arbitrary detention, there are three types of arbitrary detention. First, we have the so-called arbitrary detention by detaining a person without legal ground as provided under Article 124. And second is under Article 125 or delay the delivery of the person to a proper judicial authorities. And third, under Article 126, the so-called delaying release. And now, we will discuss about Article 124, kung unsa ni siya nga klaseng arbitrary detention. Kay kasagaran, moingon mong gudayon ta nga, ay naigidakop, ay ug dili na siya ma-file na og within 12/1836 o arbitrary na siya. But we should specify it, whether it is under Article 124, whether it is under Article 125 or under Article 126 of the Revised Penal Code. Dili ta mo pasagad og istorya directly mingon ta nga ay apply na to ang 12/1836. So dili ingon ana. Now let us discuss about Article 124 of the RPC. So unsa ang iyang mga elements? So first we have that the offender is a public officer or employee. So klaro ta, public officer or employee. So of course vested siya with the power to arrest a person. Si for example, si police officer, naman si power to arrest a person if, of course, nakakommit siya og crime, whether it is committed in his presence or committed in flagrante delicto. So, maka-arrest si police officer. Second, that he detains a person. So, of course, when you talk of detains a person, imuhang gi-deprive ang iyang liberty. You are depriving his right to, example, right to freedom, right to liberty, imo mo siyang gi-detain. And third, that the detention is without legal grounds. So, klaro ta ha, mayroong ganita og arbitrary detention by detaining a person without legal ground. Ang atuang hunahunahon diha is ning aresto ka og usa ka tawo, wala kay legal ground. We are not talking about, timan niya, we are not talking about the so-called 12/1836 basta mo-apply tag Article 124. We are talking about on the legal grounds sa pag-arrest nimo sa usa ka tawo. Gi-aresto nimo ang usa ka tawo pero way legal grounds. So pwede kang i-arbitrary ana. Pwede nimong i-arbitrary of course. Nga naman wala man siya kay legal grounds. Nga imo na siyang arestuhon. Provided also because we are talking about public officer, kinahanglan siya ni exercise siyang duty. Otherwise, di niya pwede nimong i-arbitrary. Kung panalitan si police officer ning arrest siya or si for example nag-detain siya usa ka tawo, of course si for example mingon tag without legal grounds but he is not acted on its official capacity or wala siya ni perform siyang duty but he is acting on its private capacity, ayaw i-arbitrary. Nga naman private capacity man, therefore ang atong i-applyan is kidnapping and serious illegal detention as the case may be is provided under Article 267 of the Revised Penal Code. Basta private capacity. Kaya atong istoryahan diri is public officer or employee naman. Klaro ta ha. Now, let us have an illustration. So if a person, example driving his vehicle entered a one-way street and in violation of the LTO rules and regulation was stopped by the police officer. His license was taken and gave him a ticket and was brought to the nearest PNP station and was placed behind bars. He was detained. That was 8 o'clock in the morning. Then the arresting officer left and in the afternoon the police officer returned to the police station. Upon his arrival, he immediately released the incarcerated person whom he detained for entering a one-way street. Is the said police officer liable for arbitrary detention under Article 124? So timan niya, gi-aresto siya ni police officer unsa iyang violation? Iyang violation is LTO rules and regulation. Ang imong isod sa mga hunahuna is the violation provided under Republic Act 4136 is ground na ba siya na imuhang i-arrest ang usa ka tawo si for example ingani nga ning sulod siya o one way or wala siya lisensya or expire ang ihang rehistro sa motor, grounds na ba na siya nga imo siyang arestohon o imuha siyang i-detain? So, question niya siya, is the said police officer liable for arbitrary detention? The answer is yes, he is liable for arbitrary detention. He is a public officer vested with authority to effect arrest and detain a person. Going back to the facts presented, ang iyahang offense na comment is only LTO rules and regulation. Kining LTO rules and regulation, dili na siya tantamon nga imong i-aresto ang usa ka tawo nga ni-commit siya og violation. Violation si for example on Republic Act 4136. Ha? Either imong i-confiscate ang iyang license or pwede mingon ta i-impound nimo ang iyang motor but not imo siyang i-detain. Nga naman, wala kay legal grounds to detain the person kung i-violate lang siya sa LTO rules and regulation because the penalty is not to detain the person. But say for example, i-confiscate nimo or impound nimo ang motor, depende sa circumstansya, but dili nimo na siya i-aresto. Basta LTO rules and regulation. Based on the facts, imong gi-aresto o gi-detain ang sa katao. He was detained. Klaro ha? He was detained. That was 8 o'clock in the morning, gin-arresting Officer Leaf. On the afternoon, the police officer returned to the police station. Upon his arrival, he immediately released the incarcerated person whom he detained for entering on a one-way street. Klaro ta ha? Wala ta nag-istorya diri about the time or period nga nagstay siya sa detention cell. Atong gi-istoryahan diri is the grounds na ba kay legal grounds to arrest a person. But based on the facts presented, wala siya legal grounds to arrest a person because the crime committed or the offense committed was only in violation of LTO rules and regulation. Therefore, the police officer committed arbitrary detention as provided under Article 124 of the Revised Penal Code. Klaro ha? Bantayan nato ang pag-aresto whether or not na ba kay legal grounds to arrest a person. Kung wala kay legal grounds to arrest a person because the offense committed by the culprit or perpetrator does not provide. See, for example, nga imo siyang i-detain or i-arrest most specifically or especially on the violation of LTO rules and regulation. Bantayan na siya. Therefore, on the case nga ako ang gihatag, liable siya for arbitrary detention. Another example, what if X is suspected to be a snatcher and many complaints was filed against him? One time when the police officers were conducting patrol, they saw X who was perhaps waiting for a ride. Nakita ra ha? Si X is nagpaabot siya kasakyan. When the police officers saw X, they immediately arrested X and brought him to the nearest police station. They told X that he is to be investigated for he is said to be a cell phone snatcher. So he was brought to the investigation room. However, the investigation officer was not around. So the arresting officer told him that he needs to be investigated and that he can leave but he must make sure to come back for purpose of investigation or purposes of investigation. Otherwise, if he does not come back, the next time they see him, they will kill him. Di man niya ang wording sa, they will kill him. So because of that, X would get out of the precinct but would immediately return. Are the police officers liable for arbitrary detention? Now, atong tanawon ng facts. Based on the facts, is the police officers has the intent nga i-detain si perpetrator or sa iyahang gituhuan nga kini ang gitawag nato nga snatcher na by intention nga i-detain? So atong tanawon, di ba based on the facts presented or the given facts, niya na ang facts nga ilaharanggi buhian. Kay walay investigator si arresting officer, walay investigator pag-abot sa police station, ilahang gibuhian. But there is an issue there. Why? Because niya na si police officer nga or arresting officer, kung dili gani ka mo balik, inig-abot sa investigating officer, kay pati yung tika. So magnuno na ta, is there another crime committed by the public officer? Now, let us say, the answer is no. The police officers are not liable for arbitrary detention. Sa ginaingon po na, there is no intent to restrain or detain the person or liberty of X, the offended party. In order to amount arbitrary detention, it is necessary that the intent of the public officer to restrain the person or liberty of the offended party must be manifest and it must be evident. Based on the facts nga ako ang gihatag ninyo ganiha, wala tay makita nga any manifestation or any evidence that will prove nga moingon ta nga the police officer has the intent to incarcerate, has the intent to detain a person. Why? Iya man gibuhian. But iya harang giistoryahan nga inigabot sa investigator kung pabalikon siya, mobalik siya. Otherwise, kay patyon siya. Now, atong i-assess ang facts. Is the police officer committing another crime or committed another crime? Committed another crime instead of arbitrary detention? The answer is yes. Yes, natakaroon nga naman. Because the act of sa pag-ingon ni police officer nga ihang patyon, if dili siya mobalik, it will constitute grave theft. Grave theft ang na-constitute nga crime. But on the case of arbitrary detention, di siya ma-held liable because there is no intent to incarcerate or detain that person. So, pwede na to i-grave theft sa pag-ingon niya nga patyon kung dili mobalik, igmaabot na ang investigating officer. So, klaro ta ha. Klaro tas ha. Article 124. Baliko na to. Article 124, focus ta sa pag-arrest sa usa ka tao nga gi-aresto siya ni police officer without legal grounds. Tima niya, without legal grounds. And of course, on the discussion of the criminal procedure, I will include on writ of habeas writ of habeas corpus, because that writ of habeas corpus is very important, or it is a remedy for a person who are deprived or who are detained without legal grounds. So muna itong gamiton ang gitawag itong writ of habeas corpus. It is a petition or a remedy of a person who detained nga gidetain siya without legal grounds. But ato na siya sa criminal procedure na to i-appeal na discussion. But based on this discussion about arbitrary detention, Article 124, ang atong timanan pirmi is gitawag nga ni aresto si police officer or public officer without legal grounds. Timaniha, without legal grounds. So I hope you understand, and thank you for listening, and God bless us all.